So, two different groups filed friend of the court briefs with the 11th Circuit Court of Appeals involving Jack Smith's attempt to appeal her dismissal of the Mar-a-Lago classified documents case, where she said Jack Smith was unconstitutionally appointed. Therefore, she dismissed the whole case about whether or not Donald Trump legally had the right to hold those documents, how they were held, etc., and basically said Donald Trump gets to go free, and start all over. Well, these two groups have filed a friend of the court brief and said, hey, Jack Smith didn't ask for you to take Judge Cannon off this case, but she needs to go, and here's why. And these two groups include attorneys, law professors, former DOJ officials, and at least one retired judge. Now, what is the reasonings? Well, they said beyond the fact that there's like 40 or 50 years of precedent saying special counsels are constitutional and the way this was done is constitutional. And the only opinion where they can find where anybody says that it is unconstitutional that wasn't overturned anywhere was this concurring opinion by Clarence Thomas. And concurring opinions are not case law, they are not precedent setting. They're just another judge's opinion in agreement with the majority in that case. So his concurring opinion isn't considered proof for anything. Okay. They said besides that, there are three main issues. First of all, is when they were going through the search warrant and they had conducted the search warrant and they got the search warrant, the DOJ did, from the other judge, from a different judge. Donald Trump went to Judge Cannon and basically said, prevent them from looking at any of the documents that they took from me. Well, she said, okay. And that's what she ruled. Jack Smith appealed that. The 11th Circuit said, yeah, we're not doing that. You had no jurisdiction to say that. Reverse your decision. And she did. Then there was the jury instructions that she gave in this case, where basically she said to them, well ahead of any point when you would need jury instructions, she was asking about jury instructions for the Presidential Records Act. And if I say the Presidential Records Act applies to these, how would you instruct the jury? Or do we need to instruct the jury that they need to decide whether or not these fall under the Presidential Records Act, etc.? And basically, she hamstringed Jack Smith by asking for jury instructions ahead of when they would be needed and made it way more complicated and was trying to hamstring his case. And then she said, and then basically the last thing was she had this case for over a year and made no meaningful progress. They are no closer, or were no closer, to going to trial when she dismissed it than they were basically when she got the case. There was tons of motions that she hadn't addressed. There was tons of things she hadn't done. She kept setting more and more hearing dates. Well, I want to hear more about this. We'll hold a hearing. She'll wait as long as she could to issue a ruling, and then she would have another hearing about something else. And basically, she just dragged this case out as long as she possibly could. So they are saying, hey, Jack Smith did not ask you to kick her off this case, but we are. Now, we are not party to this case, but here's all of our legal explanation as to why we think she needs to go. And, here, you can look at this. And they had to ask permission from the 11th Circuit to file this. And the 11th Circuit said, yes, you can. And they will look at it. They can consider it. But they don't have to abide by it. They don't have to do anything with it other than look at it. And they may not even need it for their consideration. But these two groups have said Judge Cannon needs to go because of how badly she has handled this case. So we will see what the 11th Circuit does whenever they get around to hearing oral arguments and then finally ruling on Jack Smith's appeal of the classified documents case in Florida.